the rights of the Palestinians, their civil and religious rights, which means that they rejected the whole concept of a Jewish state or the permanent establishment of settlements. Now that came before the Balfour Declaration, and it came before the mandate was actually ratified by the League. Now why is that important? Because it shows to you what the mandate really meant for Palestine and what Article 6 in the mandate that talked about the settlements meant. Now finally, another fact that Professor Kontorovich does not mention is the 1939 White Paper, which repudiated any conception of either a Jewish state, and in Article 3 of the White Paper it said that settlements, Jewish settlements must be curtailed, must be severely curtailed because they are prejudicing already the rights of the Palestinians. Now why is this important from an international perspective? It is important from the international perspective because the covenant of the League of Nations basically said that the League only had supervisory power over the mandatory. Now who was the mandatory of Palestine at that point? The British. What that meant was the British had absolute control over that territory to do whatever they wanted, rightly or wrongly. We may not like that fact. Obviously, even from a Palestinian perspective, it's objectionable because of the fact that it was a colonial enterprise, and to essentially appease Woodrow Wilson, they said, we'll prepare these people for self-government when they actually had colonial designs. But the fact of the matter is that as a principle of international law, the League recognized that it only would supervise the mandatory. The mandatory had absolute control and power over the territory to do what it pleased. And in Article 3 of the White Paper, the mandatory said no more Jewish settlements, which meant that Article 6 of the mandate, which encouraged them in the beginning, was rendered irrelevant. Now, the second point that I would like to make is that, as Professor Kontorovich recognizes, the international consensus says that the Geneva Conventions apply to the Palestinian territories. The reason why that is so is because they apply to all people in an armed conflict, regardless of whether they are citizens of a state or whether they are stateless. That is something that was essentially ratified by the Geneva Convention meetings in 1999 and 2004. Israel was present at those meetings. Everyone who is a signatory to that agreement has said that they apply to the Palestinian territories. Repeatedly, the international community has said that they are applicable. Now, Professor Kontorovich mentioned something about the high contracting parties. The way to really look at it is the way that the International Court of Justice looked at it, which is essentially that the armed conflict, before 1967, he's correct, that Jordan occupied the West Bank. That's true. Obviously, it did it in agreement with Israel. In the 1940s, there was a secret pact with Golda Meir and King Abdullah, where they essentially decided to treat the West Bank as spoils of war. Jordan would take the West Bank so long as it didn't essentially intervene in Israel's plans to conquer the territory beyond the 1948 UN partition plan. So to basically make such a big fuss about, oh, Jordan occupied this illegally, is irrelevant because Israel aided and abetted Jordan's illegal occupation. And by the same token, you cannot have it both ways. If Jordan's occupation of the West Bank is illegal, so is Israel's. There shouldn't be a double standard about that. Under international law, at least, they're both illegal. Now, the Geneva Conventions, the way the ICJ applied this provision was, it said that the high contracting parties in 1967 during the conflict were Jordan and Israel. And the unarmed civilians who were trapped in that conflict were the Palestinians. So you fulfill the requirements of the Geneva Conventions in terms of any kind of dispute being the high contracting parties. One of them is Jordan, the other is Israel, and essentially you have these trapped, unarmed civilians in Palestine, Arab inhabitants who are locked in this conflict between these two countries. That makes perfect sense. I mean, if you really think about this, the Geneva Conventions, if they didn't apply to unarmed civilians or stateless people, then essentially it would just become an object of abuse. So it's never been interpreted in that way. The International Committee of the Red Cross, which is given significant weight in terms of how it interprets the provisions, has repeatedly said that they apply to the Palestinian community. The International Court of Justice has said it. Virtually every country in this world, with the exception of Israel and a few Micronesian islands, think that the Geneva Conventions apply. Now, let's focus on the language that Professor Kontorovich correctly points out is debatably applicable to Gaza and the West Bank, which would be Article 49, paragraph 6. It says, Israel shall not deport or transfer parts of its own civilian population into the territories it occupies. Now notice that nowhere in this sentence does it say anything about any of these transfers being voluntary or involuntary. It says Israel shall not transfer them. Does it place any kind of limitation on how Israel can do it? No. The International Court of Justice correctly interprets this provision to mean that Israel shall not organize, encourage, or facilitate the transfers. Now let's look at this in a very practical way. How does this happen? This has been happening since 1967. I'll give you the best example of how this just happens. Just a few months ago, when the Palestinians decided that they were going to take their bid to the UN to become a non-member state, essentially Israel reacted the next day by punishing the Palestinians by coming up with a new plan for Israeli settlements in the E1 zone of Jerusalem. At that point, Israel doubled its budget for the West Bank settlements. Remember, many of these buildings are subsidized by the Israeli government. They aren't being done by private organizations just running amok and doing this while Israel has no control of them. Why is the government doubling its budget for it? Right? So what is it doing when it does that? It is organizing the settlements. It is encouraging the settlements. It is the real face behind the settlement construction. Second, they basically decided that they were going to construct a police station in an industrial park, 4,000 homes and 2,200 hotel rooms. And why was this done? It was done essentially to cut off the Palestinians from Ramallah and Bethlehem, essentially ending any kind of practical idea in the future that there could be a two-state settlement. Because once they are cut off from this area, they don't have a contiguous area anymore. So what does that show? This is just one example out of hundreds. It shows that there is strategic depth, vision, deliberate planning activity designed to do it for a political goal. All of that means what? That it's not just being done to voluntarily allow a few Jewish people from Israel to go and settle somewhere. There's a strategic vision to it, depth. And the whole idea of it is that it's being done for a political vision. Similarly, all the settlements that are being constructed in the West Bank are constructed in a way with roads and other ways in which they obstruct and essentially create the entire territory into cantons, enclaves. And the whole idea of doing this is to make their lives essentially so miserable that they flee. And this is something that many Israeli leaders have said over the years that they want to do this, because from the beginning they wanted to capture all of the West Bank and Gaza. Now, Article 47 of the Geneva Conventions prohibits annexation in whole or in part of the occupied territory. This has already happened. This is a provision that Professor Kontorovich never mentioned, and Israel has violated it. Article 46 of the Geneva Convention says that private property must be respected and must not be confiscated. Now, what happens when Israel builds these settlements? It's not building them on empty land. Israeli bulldozers go there with government support. The IDF, the Israeli Defense Forces, go there, destroy Arab land, destroy Arab homes in order to build these settlements. They're not being built up in the air. Israel, that's how it's encouraging, facilitating, and essentially building the settlements. Now, all of this under this provision means what? That it is transferring this population. And that's the consensus of the international community, and the facts show that that is basically what is happening. Article 53 of the Geneva Conventions prohibits the destruction of personal property in the occupied territories. The West Bank and Gaza are occupied territories. You send in bulldozers to destroy homes to build a settlement, you violate Article 53. Now, finally, I know that Professor Kontorovich had limited his argument to the Geneva Conventions and the mandate, and I know that we don't have a lot of time, but I wanted to mention something else which is part of international law. We all agree, I hope, that UN Security Council resolutions are binding on everyone, all the UN member states. UN Resolution 242 says that Israel should withdraw from territories occupied in the recent conflict, which meaning 1967. Now, Israel has a very legitimate argument that there's some sort of ambiguity in this, because in the initial draft of this, it said the territories, and it was changed at the behest of the United States under Israeli pressure to make it territories. Even though all the other members of the UN Security Council at that point had the understanding that what it really meant was that it should withdraw from the Sinai, the West Bank, Gaza, the Golan Heights. But essentially, this is the way that this language was changed because America and Israel didn't want it. But at the same time, it essentially doesn't say whether all territories should essentially, that the occupation should end in all territories or some territories. That's the critical question. Because if Israel says that it has the right to remove itself from some of them, why doesn't it say some territories? It doesn't say that. True, it doesn't say all territories either, but UN Resolution 298 made it very clear, which was essentially adopted in 1971, that Israel must stop expropriating land in Jerusalem and must stop transferring the civilian population in Jerusalem. The language is very clear, meaning don't make settlements in Jerusalem. Again, UN Resolution 446, that just ends this debate right here. Quote unquote, it says, the policy and practice of Israel establishing settlements in the Palestinian and Arab territories occupied in 1967 have no legal validity and are serious obstructions to peace. UN Resolution 478 condemned Israel's law declaring Jerusalem as its capital and said it was violating international law and as an occupying power, quote unquote, cannot alter the character of the city. Thank you.
Thank you, Mr. Jafri. Just a couple words in response. I'll try to keep it short to allow for some time for questions. Much reference was made to the international consensus and the large number of United Nations resolutions. It's true that there is such a consensus. It's absolutely undeniable. If international law were a game show, were a reality show, Israel would clearly be voted off the island. But the entire purpose of law, of rules, as opposed to popularity contests, is to treat similar cases in similar ways, to have general principles of general applicability applied to unknown future cases. And despite staking such a position about the legality of Israeli settlements, the international community has failed to apply this position to much more egregious cases, suggesting that this is not a rule about 49.6, but rather a rule about Israel. That's not really a rule. That's a... I don't want to characterize it. Again, 49.6, transfer. So I think Mr. Jafri and I are actually in vast agreement. Really our principal dispute may be on the facts. Let's concede that the Geneva Convention applies. And then let's again, let's concede that the Geneva Convention applies. The question is, what is a transfer? I think the international community does not, the international consensus does not support Mr. Jafri's view. Mr. Jafri wants to say that it's when Israel organizes settlers and builds their houses, that's transfer. But you know, there's that's not the standard view. Take, for example, the phenomenon of illegal outposts. What are illegal outposts? You've heard of illegal settlements. When people talk about illegal settlements, those are settlements which the Israeli government is actually actively trying to knock down. And I know of no international source that does not argue that those are also violations of 49.6. But how come? They're illegal under Israeli military and municipal law. So shouldn't that make them legal? That is to say, shouldn't the illegal outposts be actually legal under international law? But no one says this, because the rule that people are trying to really articulate is that any Jewish civilian presence, take for example, when Jews buy houses, let's leave aside bulldozing examples, and let's take examples which are known to happen. Jews buy houses from Arabs in Eastern Jerusalem. Jews move in. Let's say there are such transactions. Maybe there's only one of them. The UN, the entire international community says that's also transfer, but it's very hard to understand how. Suggesting that the government involvement is not really what is not really what's driving this. Now today, I believe 2/3 or 3/4 of construction in the West Bank is private construction. What about tax breaks? The tax breaks that are available for moving to the West Bank are not settlement tax breaks. They're tax breaks which are equally available to moving to the north, to moving to the Negev. They're general tax breaks for not living on top of everyone else in Tel Aviv, and are not any special inducement for that. The vast majority of settlements are built on what's called state land. That is to say, land where there were no private property rights under Jordanian rule and under Turkish rule. Could some Jewish homes be built on Palestinian land? Yes. Would that be a violation of international and also Israeli law? Yes. Also vice versa. Palestinians could also trespass on Israeli land, and then their houses get knocked down, but then everyone complains. But that is to say, private property rights are a separate question. So I think the consensus, I believe, that emerges from my views and Mr. Jafri's views is that if Jews simply want to move to the West Bank, to areas that are not private property, and build houses there, that there's nothing in 49.6 that prevents such movement. And given that the current the current population of the West Bank is maybe, let's say, a mix at worst of people who might have been encouraged by the government, people who went despite government encouragement. How were the first settlements started? I think Mr. Jafri did not offer the paradigmatic case. First settlements start like this. A bunch of Jews move up to a hill, army comes and kicks them out, because they were hoping that there'd be a peace treaty any day. They come back, army kicks them out. They come back, army kicks them out. They come back, army kicks them out. Finally, the army says, we've got better things to do. They stay and build houses. Have they been transferred, or have the government just failed to retransfer them? That's all. Oh, no, come on, stop. More to go.
I just wanted to make 2 points. The first one is that Professor Kontorovich and other supporters of Israel constantly try to create this impression that Israel is some sort of victim of the international community, that all these standards apply to it and no one else. He had that long list over there. I can spend hours over here, but I only have 2 minutes telling you why I feel he's wrong about that. But I'll only give you one good example. That example is the case of Namibia, which was occupied by South Africa, and the international community had consensus that occupation was illegal. There were several actions taken over there to end that occupation, and many people, including people who would be promoting the idea of a Palestinian state under international law, think that what happened in that case can be applied to Palestine, and all the progress that was made in that case can ultimately result in a Palestinian state. So that is the most crystal clear example of why it has been applicable. The same rules have been applicable to other places. This is essentially Israel's mantra. Every time you criticize it or you say that it's violating the law, it points to the other guy and says he did it too. But a lot of the times the other guy is held accountable as well. It's just that Israel and its supporters deny this fact. So I don't want to go through that whole list because otherwise, we're going to be here all day. The second thing is, it seems that we have a fundamental disagreement on the facts. And I would agree with him that there is perhaps nothing wrong with some Jewish person legitimately going and living in a Palestinian state so long as they immigrate properly in it. But there's no system for that happening. All of this happens at the encouragement and behest of the Israeli government. Again, he says that all these settlements are essentially placed on state land, which smacks of the old myth that essentially this is essentially a land without a people for a people without a land. That's how the Israeli project was justified from the beginning, and we see this myth essentially being reinforced today. The idea that somehow this land is empty and all these people who are moving there are doing this off their own volition. This land is not empty. In the vast majority of cases, it comes by prejudicing the rights of the inhabitants, destroying their homes, destroying their Arab land, destroying their livelihoods. That's how these settlements are constructed. And who allows that to happen? It can only be a government authority that allows it to happen, and that governmental authority is Israel. And by doing that, it violates paragraph 6 of Article 49, which says that it shouldn't transfer its own civilian population into the territory that it occupies. Thank you.
We both go up there. Question time?
Sure, yes. We do have about 8 minutes for audience questions. We ask them to be limited to international law, the interpretation of international law in the settlements. And please state your name and your question. Please.
My name is Jemana. My question is, so throughout these sort of, I guess, excerpts from the Geneva Conventions, it states civilian population. But with Israel, they have a sort of rule where a draft is mandated from age 18, and throughout to like age 40 or something, every once in a while, people will be called back into the draft, essentially making Israel's quote-unquote civilian population not actually civilian population. So I was wondering how that affects, I guess, interpretation of the Geneva Conventions.
I wish I could agree with you. I wish I could agree with your premise, because the Geneva Convention, notice, does not prevent the transfer of military forces into the occupied territory. That's the essence of occupied territory, is that the occupying power's military is there. So if you were to say that all Israeli does are actually members of the military, then there'd actually be no problem sending them to the occupied territory. So I wish I could agree with that, but I can't. Because the way international law is understood in the provisions of Geneva Conventions, when it says military, it means active duty military. The fact that someone could be called up or is eligible for conscription or reserve duty does not make someone military within the purposes of the Geneva Convention in any one of the other provisions. And Israel is not really unique or unusual in having a large reserve force. Before America abolished the draft, it also had a large reserve force. And the civilian would apply to civilians who are still eligible for conscription or call-up, though that would have been a creative argument. Yes, sir.
Richard Goldwasser. Excuse me. I believe Mr. Jafri, citing UN Resolution 446, said that that provides or defines all settlements as illegal. I was wondering if you would comment on that.
Yes, was it a Security Council resolution or
I thought
Security
it was-
Council.
Security? Right. So the Security Council has authority to make binding decisions. That's quite clear. That authority is pursuant to its Chapter 7 authority to deal with resolutions to deal with what do you call it? Threats to international peace. The Security Council, however, is one of several UN institutions which coexist with the International Court of Justice. And the Security Council itself is not a judicial body and does not have the authority to reinterpret otherwise applicable law. That is to say, if the Geneva Conventions mean something, the Security Council can't redefine it, right? Nor can it, in a judicial function, apply it to particular cases. Now, if this was an article, it could use its Article 7 powers to, for example, require attacks and stuff. That's the so it could make legislative decisions, but not judicial decisions. Its interpretation of international law does have more weight than the General Assembly's. But then one would also have to look at it alongside with its other interpretations of international law and its refusal, for example, to find a 49-6 issue in Turkish settlement of northern Cyprus, Moroccan settlement of Western Sahara, and so forth. One more.
There in the back.
So I was looking at the presentation that President Kontorovich showed that there were other conflicts and just because egregious, or maybe more egregious based on what he said. But my question to you is why this particular conflict keeps taking central stage over and over again in the world? I mean, maybe more people speak about it. It's doing so puzzling.
I can't psychoanalyze the world. The British Foreign Minister, William Hague, recently addressed this issue. It's interesting that he felt compelled to speak to it. He said, you know, why do we keep saying that the Israeli-Palestinian, the Israeli-Arab conflict is so central, is so important to us? You know, we're up here on the edge of the world up in Britain. Why do we care so much about this? And he said, because this occupation, this settlement policy, you know, it may not be the worst thing in the world, but it's very close to us. You know, it's close to Europe. That's why we as Europeans care. Now that's particularly ironic because the Turkish occupation and settlement of Cyprus isn't just close to Europe, it's actually Europe, right? Western Sahara is not just close to Europe, it's like right next door. So that the close to Europe seems to, you know, well maybe it's in danger of war. War is a possibility, right? Spiral into conflict. The Kashmiri conflict is clearly, if that spirals into war, like the world is a cinder block overnight. So it's very hard for me to understand why. I don't know. I can't psychoanalyze the world. Okay.
Thank you, everybody, for attending.